Good afternoon or good morning, depending on where you are in the country. And thank you for joining us today for NASPA's live briefing to release the NASPA Title IX Proposed Rule Resource Guides. My name is Diana Ali. I am the Assistant Director of Policy Research and Advocacy here at NASPA.
Hi, everyone. My name is Terry Hines. I am NASPA's Director of Policy Research and Advocacy. Jill, do you want to introduce yourself?
Yes, my name is Jill Dunlap, and I'm the Director for Research and Practice at NASPA.
So we're going to jump right into our content today because we do want to make sure we leave plenty of time for questions. So this briefing and the resource guides that we're going to be talking about today are related to a proposed rule which has been published by the Department of Education. It was published on November 29th of 2018. The full title is listed there on the slide: Non-Discrimination on the Basis of Sex in Education Programs or Activities while Receiving Federal Financial Assistance. This is a rule that pertains to Title IX and institutional responsibility to respond to reports of sexual harassment or sexual assault on their campuses. Publishing the proposed rule, when the department published that, they also opened a 60-day comment period. So this is part of the informal rulemaking process, and we have more information available about that on our blog, or you can check out the information sessions that we did in December about the rule to find out more about what that means. But the key date to keep in mind here is that that comment period ends on January 28th of 2019. So we've provided some links on this slide. We can also send them out with the slide deck afterwards so that you can access those, but the information sessions from early December are that first link. And then we also did a 4-part blog series in December that mirrored the information session. It provided our initial analysis of those issues that we noted during our initial review of the proposed rule that we thought might be of interest to student affairs and higher education professionals. So since then, we have been working over the winter break to go into some deeper dives on some of those key proposals and changes. So we really wanted to take a look at kind of where there might be concerns or where different student affairs professionals across different campuses might want to focus if they were going to submit comments. So this, what we're presenting today, what we're released this morning, is a set of, we're calling them resource guides on Title IX, on the proposed rule. They have been they're specific to this proposed rule, so they're not necessarily going to cover a whole history of Title IX. They're not going to go into everything in the proposed rule, but they're the highlights on some of those key issues that we identified as being likely to be of most of interest to student affairs professionals on our campuses. So there are 8 of the guides. We'll go through a brief introduction of what is in each of them. The guides do overlap some in terms of the content that they cover, but we tried to keep the analysis within each guide focused on the topic for that specific guide. So you might see, if you read through all 8 of them, you might see, similar language appear in a couple of places, but we really tried to sort of break apart the different conversations and keep what we talk about for each guide a little bit more siloed so that it would be, we weren't, crossing too many threads and confusing things too much. So the other piece that's in the guides is links to a lot of research and data and other analysis, trusted sources that you can refer to, that you can reference in your comments, so that when you provide your comments, you're providing substantive comments. And that's really a key part of participating in this comment process, is that your comments are substantive, that you have evidence to back them up, that you talk about either your campus context or your professional experience, or you talk about research and data that comes from trusted sources. So we wanted to make sure that we provided plenty of that in the resource guides as well. So the link to the guides is to access them is up on the website. You can also go to naspa.org/RPI and click on the first blog post, which was posted today. That link exists there as well. So there's, it's going to take you to the same place to get access to them. You will have to register for the information session course in our online learning community in order to get access to them, but then you'll have access both to the information sessions that were done in December as well as the listening guides. So without further ado, we'll go in and do a quick summary of what's in each of the guides. As I mentioned, there are 8 of them. So the first of them is aspects of the proposed rule that may reduce reporting. So there's a few aspects in the proposed rule that we think are promising. There's a continued right for both parties to appeal findings and clarity that institutions can provide supportive services to students regardless of whether a formal complaint is filed. So those are both things that we were happy to see in this proposed rule. However, there's a lot more pieces of the rule, aspects of the rule that risk both individually and collectively prompting a decline in reporting of campus sexual harassment incidents. And many of the aspects of that rule that might result in a decrease in reporting do sort of cross over and touch into some of the other conversations and the other resource guides, but we tried to provide, again, a summary of sort of specifically those areas that were going to affect reporting rates in this resource guide. So you can see the headers that are included to give you a sense of what's in this resource guide on the slide. And again, in order to leave plenty of time for questions, I'm just going to keep moving into changes to the religious exemption process. So this one is a little bit more esoteric. It's a little bit more unknown to many campuses that the religious exemption process even exists. But the proposed rule would change the process that faith-based institutions can use to claim a religious exemption under Title IX. So institutions who request an affirmation that they have a religious exemption are basically not required to uphold student civil rights under Title IX that violate their faith. So for an example, at an institution with a religious exemption, LGBTQ students who are sexually harassed by a person of their same sex may be disciplined for violating same-sex relationship policies if they report the incident. So given the high rates of sexual harassment among LGBTQ students, we feel that it's really important for our institutions to provide transparency about whether they will protect the rights of those students if they enroll at a religiously affiliated institution. So changes to this process have been that the department has removed the requirement that institutions or the requirement that institutions seek affirmation of their religious exemption, and part of that process has been under the Obama administration that they would publish the names of the institutions that had requested a religious exemption and the reason and sort of specifically what the exemption covers. So that will be removed and the department will no longer even collect that information, so they won't be able to publish it, which is going to leave those students at best uninformed and at worst subject to discrimination at the hands of institutions that are receiving federal financial aid resources. So we find this a little bit concerning, not the fact that there's allowed a religious exemption, but that institutions don't necessarily have to be transparent with their students about what they might protect. So we want to make sure that we draw attention to that change in the proposed rule. That's not specific to the sexual harassment pieces of Title IX, it's a change to all of Title IX's coverage. So moving on to the next resource guide, we have a guide that talks about departmental overreach, and this is the Department of Education. So the proposed rule oversteps the appropriate role of a federal agency in several ways, in our opinion. The department relies in a lot of cases on very selective evidence to take a stance that assumes that our institutions are not currently engaging in fair, equitable campus conduct processes. And they're also then using that as an excuse to extend constitutional due process rights to campus conduct procedures. So the department attempts to intervene in some pretty sort of narrow campus decisions, including some campus personnel matters, by setting requirements about who can be hired to fill certain campus-based roles. So they make requirements based off of bias, but they don't define what that means. So it's unclear sort of what ripple effects that might have in terms of campus hiring and employment practices. So they also, we point out in this resource guide, they challenge the historical nature of federalism. They make some changes, some interpretive decisions in this rule that would effectively overrule a lot of state legislation, particularly state legislation that was passed that models the Obama era Title IX regulation or guidance. And so we feel that that's sort of in violation of a longstanding practice of federalism within our country. So we discuss all of those issues within the departmental overreach. And that one may be sort of, for a lot of you, it may be like, yeah, I don't really care about that one. So that may be when you skip. The next one, though, is expectations for overly legalistic processes. And this is it's related to this idea of sort of the department's role in oversight and kind of providing this guidance to campuses. So the proposed rule, the way that it is written, is it would require campuses to create a much more adversarial process for adjudication of campus sexual harassment in conduct incidents. The proposed process is repeatedly and intentionally conflated with the criminal justice process. So there's lots of calls to due process, which is it's a criminal justice definition of due process that is used within the rule. And it sort of goes against this idea that our campuses are not courts of law. But there's still, throughout the rule, there's numerous expectations, both implicit and explicit, that the department places on administrative proceedings within campuses to behave as though they are courts of law, and we feel like that's sort of taking that requirement a little bit beyond where they should be going. So we talk about constitutional due process. We talk about the overly legalistic aspects, the requirement for live hearings and mandatory cross-examination, the involvement of attorneys, restrictions on what can and cannot be used for the standard of evidence. Those are all sort of pulled into that expectations for overly legalistic processes resource guide. Moving into the next one, so we're on number 5 if you're keeping track. We have the impact on institutional staffing and capacity. So there are many aspects of the proposed rule that raise concerns around institutional staffing and capacity, and this is both true for both very large and very small institutions. So changes to the policy on campus indicating who's considered a responsible employee, and the narrower definition of what constitutes actual knowledge, which we discuss also in the resource guide on institutional responsibility, which Jill will talk about in just a minute. But those are only parts of the concern. When you combine those with requirements that the Title IX coordinator would be the person responsible for arranging all of the supported services on campus. So maybe if you have campus advocates, respondent rights advocates, or respondent advocates as well as complainant advocates that are currently managing that supportive services coordination, that would now be a responsibility of your Title IX coordinator solely as far as how we read the rule. There's also some issues about the number of individuals that would be required to participate in a formal grievance process. So depending on who you considered required and whether or not you assume that the parties are going to engage external advisors or attorneys, that's anywhere from 5 to 7 specific individuals that would need to be involved in this process. And for very small campuses, that's a large number of people that would need to be engaged. So we cover those as well as some of the costs for training and retraining of students, faculty, and administrators. So we've been telling them one thing about sort of responsible employees, and now that would change under this proposed rule, and we don't believe that the department really addresses that very well in considering the costs for what this is going to mean for campuses to implement. So we talk about that a little bit more in this resource guide. So I think now I'm going to turn it over to Jill for her rapid fire description of our last 3 guides.
Thanks, Terry. So sort of dovetailing into what Terry was talking about with regard to informal resolution, it's the guide that we have drafted talks a little bit about the fact that this bullet point says the operationalization of informal resolution processes when really there isn't any found in the proposed rule. So one significant way that this rule differs from previous Title IX guidance is the allowance of informal resolution procedures to resolve sexual harassment cases. And for some, this is a really welcome shift for those practitioners who recognize the value in less adversarial processes. And according to the Association of American Universities Campus Climate Survey report, which is linked in the resource guide for your use when you're drafting your own comments, 24% of victims surveyed in their study listed social-related reasons for why they didn't report, including, quote, "I did not want the person to get in trouble." And that's what this really speaks to. And so for, like I said, for some people, this is a really welcome opening of that door to informal processes. The trouble, again, is that they haven't really operationalized that in terms of what sort of training would be needed for those who are running more informal processes and, as opposed to those who are perhaps involved in the adjudication and the more formal adversarial processes that are outlined under the proposed rule. The inclusion of informal processes is especially mediation and arbitration, which are both mentioned within the proposed rule, it runs the danger in the minds of some of taking us back to a time where complainants or student survivors of sexual harassment come forward and are sort of pressured or coerced into doing something that is a less formal process. And so the understanding the real differences between mediation and arbitration is something that this resource guide goes into. So if you're interested in that, I suggest you take a look at that guide specifically. And then again, sort of outlining that, restorative justice processes, which are in place in many campuses, although not frequently in use currently for sexual harassment cases, is a viable option for many campuses that they would like to look at. But again, this sort of lack of formal guidance around or suggested guidance around how that might be operationalized is something that we have concerns about, and that is outlined clearly in the resource guide that we have. So then moving forward to our last couple of resource guides, I'll just run through these really quickly so we can have time for questions from you all. This is the resolution timeline. So one of the elements of the proposed rule that has again received some warm welcome from those of us who have done this work is the elimination of a 60-day resolution timeline. The proposed rule doesn't include mention of any specific time frame for resolution of investigations, instead stating that institutions are to designate reasonably prompt time frames that may be extended for good cause. What was felt by some practitioners under previous guidance as an overly stringent time frame requirement for investigation has been replaced by the complete lack of a time frame, which also causes equal concern among those who are doing this work every day. Complicating matters, the department has added 2 mandatory 10-day review periods to the formal investigative process and has potentially opened the door for additional delays due to scheduling for advisors that are now required as part of a live hearing and any necessary witnesses for that live hearing. So for more information on that and the resolution timeline, please do see the NASPA Title IX resource guide on resolution timelines. One of the things we heard from our members loud and clear when we did our listening sessions back in March was that there was some anxiety around having no timeline and time frame under which to hold institutions and themselves accountable to the process, and that getting buy-in from students who may be participants in that process, either as respondents or complainants, will be significantly impacted when we can't sort of describe the beginning, middle, and end of what that process might look like. And then finally, the scope of institutional responsibility changes under the proposed rule. One of the primary ways that this differs from previous guidance issued by the Department of Education's Office for Civil Rights is the narrower definition of harassment prohibited under Title IX. There's been a lot of discussion about this on different blogs and then within different associations. There's a significant change in the scope of institutional responsibility to investigate allegations of sexual harassment within the new rule. The change to the standard by which institutions are considered to have actual knowledge of sexual misconduct has also been narrowed under the new rule, as has the responsibility for institutions to investigate and adjudicate misconduct that occurs outside of official programs and activities of the institution. These changes represent a substantial shift in the ways that the institutions will be required to address sexual harassment involving students. And again, we go further into depth on this particular topic in the NASPA Title IX resource guide under scope of institutional responsibility. So those are some high-level highlights of what the guides cover. I think, if I'm not mistaken, Terry, we will open it up at this point for questions from anyone who is near the keyboard and has questions about the guides or any of the concerns that we have laid out here.
Yeah, so our first question coming in, thank you both for that really quick and succinct rundown of the resource guides, which are available to you all now on the NASPA RPI website, as well as the online learning community. Our first question that we got is a really interesting one. In consideration of the federal government shutdown, is there any likelihood of getting an extension to the notice and comment period?
Yeah, so I will take that one. So it's interesting. It's a partial shutdown, which is it's important to remember in this particular case because the Department of Education is actually still operating under full funding. So they were one of the departments that their budget bill was passed. So the department is still open. They are still operating. You may have seen earlier this week that they have started to organize for the negotiated rulemaking that they're doing on accreditation and other issues. So the department is still active. The shutdown is unlikely to result in any kind of extension to the comment period. The Federal Register is currently not operating. The feeds between the Federal Register and their email is currently not going out. However, the regulations.gov website is still fully functional, and other agencies have other comment periods that are ongoing that are still opening and closing as scheduled on that site. So we do not expect to see any kind of extension to the comment period because of the partial shutdown of the government. So unfortunately, no reprieve there. You're going to need to get your homework in on time.
Okay, thank you, Terry. So we don't have any additional questions at this time. I know that during the information sessions, we did have a lot of questions come in, so this is a chance for you all to submit additional questions if you have them. One kind of reoccurring question that we've been getting and that I'd like to open it up to Terry and Jill is about kind of the possible repercussions of submitting comments given working as a student affairs professional at an institution, and if either Terry or Jill have any tips around submitting individual comments.
Sure. So I can start, and Jill, by all means, having been in that position, if you want to add any information, please feel free to do so. So one of the core tenets of NASPA as an association is we believe that civic engagement should be supported. And so participating in the comment process, either as an individual or as contributing to any comments that your institution might be planning to submit, or encouraging your institution to engage in submitting comments, is definitely something that we support. But we are also aware that that can put some institutions or some individuals in some sensitive positions. So if your institution either isn't planning to comment or is planning to comment on things that maybe you disagree with as a personal professional, you are still, we would still encourage you to submit your comments and to submit your experiences to the department. You can do so without identifying yourself. You can do so without identifying the institution that you work with. There are ways that you can establish your credibility as a professional working in this field by what you say without sort of revealing where you are or where you're working. And we will, we have a resource that will be coming out next week on the RPI blog that will provide a little bit more information about how you sort of establish credibility as an individual in giving your comments, and that applies whether or not you sign them with your name or you don't. You can submit anonymous comments, but it is pretty important if you're going to submit an anonymous comment that you do take some time to sort of to lay out sort of where your experience comes from and why your voice matters in this conversation. Good regulation really comes from the collective experience of experts around our country, and that's you all. So we need you to participate in this process, to provide your experiences and your expertise to the department. You know, there are a lot of very good career staff in the Department of Education who really are trying to make good regulation on behalf of students. They may differ from us in terms of opinions about what they think that regulation looks like, but the best way for us to participate and to give them the benefit of our experience and our expertise is to participate in the comment process. So just from a government affairs or a policy perspective, that's my encouragement there. Jill, I don't know if you wanted to add anything.
No, I think that was really well put, and I think that I appreciate, Diana, that you acknowledge the question that we've received and that we've been hearing it in a couple of different places, and that the fear of sort of the political repercussions on campus is a real one. And so the desire to contribute meaningfully is something that is important to so many of us who have done this work for decades, some of us. And so the opportunity to have input is important to us personally and professionally, and yet many of us aren't in a place or at a capacity where we can sign and say that we are in X, Y, or Z role at X, Y, or Z institution, and so that feels limiting. And yet I agree with Terry that the importance of having those voices, and that you can point to your expertise without necessarily naming an institution, that point to your years of experience. Many of us have served in various capacities and different roles, in terms of sexual violence prevention and response on campus, that I think that those are just equally as valuable, as Terry said. And Terry, if I'm not correct, and this isn't meant to like intimidate people, but it is searchable. So if you sign your name in any way, shape, or form, you can search the comments. Is that correct?
That is correct. Public comments are public. So once you submit them, they appear on the website. I think there's a short review period where they just make sure that they're not, there's no profanity or whatever in them, but the public comments are a matter of public record.
And there's been some concern, I think, about people with the new bias clause under the proposed rule, that they would submit comments that then might be used later as a form of or as evidence of bias. So again, I think those concerns are real, and we're not here to discourage you from submitting comments, but to do so in a way that makes sense for you.
Thank you both. So I think we have time for one more question. So this is a very specific question to the Institutional Responsibility Guide, asking for some clarification. So the question is, are we interpreting the provision to mean that institutions cannot investigate off-campus sexual misconduct, or rather that institutions can investigate, but it is not required under Title IX?
Do you want me to answer that, Terry?
Go for it.
Okay, so I'll start and then you can wrap it up if you want, Terry. But I think our understanding is that it's written a couple of different ways in a couple of different places. So it's one of those things that we're sort of waiting to see how that shakes out. But that I think our understanding is the latter in the way that Diana described it, in that it's not that campuses can't investigate misconduct that occurs off campus that would be a violation of the student code of conduct. It just wouldn't be done under a Title IX process. Is that your understanding as well, Terry?
Yeah, and it's a little unclear sort of how how those two processes are intended to intersect, or if they're intended to intersect. So there's been a lot of conversation within the Higher Education Association community. I would expect that there will be associations and individuals that will ask for clarification about that. I know that it's stated in the preamble, which is not binding, that's sort of the text description that comes along with the regulation, that campuses are still able to adjudicate codes of conduct violation under their own codes of conduct, that even if they don't meet the definition under Title IX. However, it's not quite so explicitly stated in the actual text of the regulation. So I think that asking for clarification for the department, and even going so far as to asking the department to codify that right does exist within the regulation is something that I think is certainly possible, and we're likely to see that come from many of the association comments as well.
Okay, thank you both so much. So as a reminder, like I mentioned at the beginning of the presentation, this recording will be available following the presentation, but also if you're trying to access the guides and you're having some difficulty registering through the online learning community, you can reach out to Jace Kirshner, who is on the call today, and who should be able to help you with that. But these guides are also available on the Research and Policy Institute website, and there's no registration required in order to access them there, I believe. So I want to thank Jill and Terry. We really appreciate the time and effort that you put into the session today. And we will communicate via email to let you know when the recording is up online. Thanks so much for your time today, and I hope everybody has a great afternoon.
Thanks, Diana. Thanks, Jill.